Hi, my name is William Pittenger, Wichita Falls, Texas, and uh, and I'm here today, and I am going to read again out of the Constitution, Amendment 14, Section 1. After I have read the amendment, I will try to make my comments as brief as possible. Amendment 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. I was a tax preparer for 6 years, and for 3 years I prepared taxes for international students at Cameron University in Lawton, Oklahoma. And this was a learning experience because professional tax preparation businesses do not offer training for preparing taxes for students who come here to get their education from abroad. I had to get the law and the treaties out of the IRS, and I also had to take several classes separately in order to make myself qualified to file taxes for international citizens. During that process, I also learned a little bit about the immigration process through the law. And what I learned is that there are 4 processes that a foreign-born citizen needs to take upon entering the United States. The first one, obviously, is the green card, in which a foreign citizen applies to the U.S. consulate in their nation, and then they are run through a set of criteria, and then at the end of that criteria, if they meet all the requirements, they are granted a green card, which gives them basically a work permit in the United States. When they get here to the United States, any monies that they receive while they are working here, they have to pay taxes on. Okay, so that's the first law. The second law is student F1 visa status. And this is when foreign students, by a treaty, a tax treaty of the United States, are granted they're granted residence in the United States, not citizenship. They're granted residence in the United States, so that they could get the education at the specific college that they were accepted to attend. There is a criteria for foreign students coming to the United States under F1 visa that must be met. Then there is F2 status, and this is for foreigners who have a specific skill set that the United States does not have, in which they are invited to the United States to teach for a limited amount of time they teach or they offer these specific services and a skill set because these specific skill sets are not available on the common market. They can't be hired in the United States. This is anywhere from 3 to 5 years where they live here paying limited taxes on their incomes, and it also depends on the treaty. And we have treaties with nearly every nation on the globe. Then there is the H-1-B status. The H-1-B status is an employer sponsorship for a student who has gotten their education in a specific field, and an employer is willing to foot the bill for completing the work requirements for someone to work for them. This can be expensive, but the employer makes a determination that yes, this person is worth it. They will remain under my employ, and I will provide progress reports on a regular basis, so on and so forth. Those are the primary criteria that have to be met in order for someone to be granted entrance in the United States, as well as ability to work in the United States. F1 students, by the way, are limited to working on their college campuses as per an agreement between the United States government and the foreign governments that allow them to come here. That is for the U.S. protection and for the students' protection. There is a special form that must be filled out, which grants them, in connection with their education, the right to work outside that setting. According to current statistics and other research that has been done over the last 10 years, the United States grants over 1 million requests for entry into the United States a year, and this process takes between 12 and 20 years in order for them to get their citizenship completely granted. They must reapply for citizenship at 6 years. If they don't and they continue to remain, they're illegal aliens. Then they must reapply again at the end of 12 years. If they fail to reapply at the end of 12 years and they still remain, they're illegal aliens. Most people, by the time they have gone through the process from entry to citizenship, has taken between 14 and 20 years. So what I wanted to comment on is this 10-point plan for granting amnesty to up to 12 million illegal aliens. And that would be in connection with Amendment 14. First of all, there are many people who have applied to the United States for entrance, education, and there are many who are within the United States who have been through the process, who are maybe on their 15th year, and they still may not realize their citizenship until the 20th year. And now what he's saying is all those people who entered the United States illegally, who have not been through the process, will be granted citizenship before they are. Now this obviously is wrong. You do not, if you grant these people citizenship and they're here illegally, then that tells all the rest of the people that have applied and have been through the process, or that they can just stay here. They don't need to reapply. They're American citizens, and they can use their temporary Social Security cards, which has been known to happen, to file taxes as American citizens and live as American citizens when they are, in all actuality, not. Another point to make about this amnesty is that in Amendment 14, Section 1, it states specifically, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Understand that the United States Constitution was not made for illegal aliens. It was made for citizens of the United States, specifically, whether born or naturalized. And on another note, if you go back to forefathers' intent, when they said all persons born or naturalized in the United States and subject to the jurisdiction thereof, they were not referring to illegal aliens bearing children who would then be called United States citizens just because they were born on United States soil. No, that was not the intention. The intention was that if you were here, you were born here, and you had children here, or you were naturalized here and you had children here, then and only then are they United States citizens. That does not say that an illegal immigrant comes over here, has kids, and oh, I've got an anchor baby. That anchor baby is a United States citizen, and so by virtue of the fact that he was born on U.S. soil, I get to stay here. It doesn't work that way. A third point is when you grant amnesty to up to 12 million illegal immigrants, what you are doing is you are saying that you are going to give them precedence for employment potentially over American citizens, which abridges their privileges and immunities as citizens of the United States, and by virtue of the fact that they won't be able to get employment because of the illegal immigration or the amnesty granted to them, they will be deprived of life, liberty, and property because they were processed into the United States under amnesty without due process of law. So the executive order, if the President of the United States attempts to wing it on his own outside the Constitution of the United States and outside the legislative body of Congress, which I read to you last week in Article 1, Section 8, President has no authority to do that, and Congress will have the right to move upon impeachment if he attempts to push this legislation through on his own. As he said in 2011, the Constitution prevents the President of the United States from acting on his own unilaterally. This is William Pittenger, Wichita Falls, Texas. Thank you.